our system better than 20 years ago.
Tell me more, because from where I sit as a journalist and I get the opportunity to interact with different people from different facets of our society, people have had to go through land litigation for as long as their own lives. Some have died whilst waiting for some adjudication on property that was in contention in the court. To the extent that somewhere between 2006 and 2008, under President Kufuor, they had to introduce the fast-track High Court. That was to indicate to all of us that the justice system was extremely slow and needed certain amendments to the law to ensure that there was speed in respect of particular cases and so on. You say much has since changed since ADR was introduced.
Much has since changed. As of 2001, this edifice, the law court complex, did not exist. If you walk around and you see the comfort in which people access justice these days in this building, that was not in existence in Accra then, not even at the fast-track court, where people get in such an environment for access to justice. We have had many specialized courts than ever. We've had commercial court, we have human rights court, labor court, we now have general jurisdiction, we have probate, we have land, we have that, we have that. All these things are interventions that have accelerated, efficient access to justice. We have had, massive capacity building for judges. We have had massive capacity building for departmental health, units that play complementary role to the judiciary, and above all, alternative dispute resolution department. As at that time, there was no directorate. Mm-hmm. There was nothing like national ADR coordinator who is pushing for policy and programs that integrate alternative interventions to dispute resolution. Now we have it, and over 131 courts are staffed with trained mediated by the judicial service across the nation who help people to resolve disputes that would have traveled so long and parties to it could have died without getting access or the benefit of the fruit of their toil, as you cited. But today, we have a system whose processes can take just an hour to resolve a case that would have traveled 10 years, 15 years, and all that. So we can't say we have, we are there, we have arrived yet, but we have come very far. And it is only when we take time to look at both sides of the coin that we see what we have been able to do. Unfortunately, human beings are susceptible to only looking at the downsides of life always. And that is very, very disheartening. It doesn't help us to sometimes thank God for the grace that has sustained us. But I think that we have come far and we can do more.
I'll be asking you soon what kind of cases can be referred to ADR practitioners. But even before I get there, so we know that when you go to the courts, you have lawyers who then you can contract to speak to the courts on your behalf and make your case for you. But in cases where people then resort to this relatively new system, ADR, who are the practitioners? How are they trained? Who are they trained by? Who qualifies to be a practitioner of ADR to start with?
A loaded question. I pray that I'm able to deal with them fully. Yes, when you come to the court and you are litigating, then the show is between judges and lawyers. The disputing parties, the litigants in court, they take a back seat and observe the lawyer and the judge manage their case. The concept of alternative dispute resolution is that the case in court belongs to the plaintiff and the defendant. The parties who are in court, who have engaged lawyers handling the case before the judge, are the owners of the case. So they have the foremost appreciation of what their needs are. They have their expectation. It is when, at the end of the day, their expectations are not met that they say the judge is wrong or they are not happy with the courts. Because they come to the court and being owners of the court, they are not directly involved. Somebody takes over and says, I am an expert, I am the lawyer, so let me do your case. While sitting and watching, it is very difficult if something is said wrongly then to correct it. You will not have the opportunity to correct it until the judge adjourns the case and meet your lawyer later. If it is fatal, then you are now going to find a legal means of correcting it. These are some of the challenges. So ADR is saying that let us empower the disputing parties, let us create an environment for them so that they can meet, and when they meet, they discuss the case in their language within their level, within their context, to find out as to what they think their solutions are. Help them to handle those solutions and record them as a judgment of the court. So that is precisely what we do. And these parties, when they are referred to ADR, they do not need to necessarily be represented by lawyers. That is one advantage. So the point is that before the lawyer understood the case and was able to determine the area of law under which the case falls, the party has to explain, narrate the story to the lawyer. So if you are looking for a person who is better able to present his case in his own language, to suggest a solution he prefers, then that person, the party, is the best person to be given the opportunity to discuss it. So they don't need to be represented by lawyers unless, of course, they insist on that right, because representation of a lawyer of a client is a right. And so if the person decides that even though it is an informal environment, I insist that a lawyer goes with me, the lawyer will be allowed. He can even say that I am not going to talk, so my lawyer should talk for me. Even when the lawyer is appointed to represent somebody at ADR, that lawyer is not going to behave as if he's standing before a judge in court. He's going to talk as a party at a negotiation table, picking a direct instruction from the disputing party as to what the disputing party thinks is his or her solution, without necessarily insisting on the relevant rules or laws in the case. Yes. So parties can go without lawyers too. And you ask, who qualifies to be to assist the parties?
Yes.
The person who qualifies to assist the parties at ADR does not necessarily need to be a lawyer. He only needs to be able to read and write, who is capable of being trained in the principles of ADR, who who can operate and apply.
In this case, when you, sorry to interrupt there, but when you talk about assist, are you replacing the word assist with mediate, for example, or we have assistants and mediators?
We have mediators, right, whose role facilitate a dialogue between the parties. So it is the function of the ADR process, the mediator, creating the environment, mediating and all that I'm referring to as an assistance.
Thank you.
But it is not the word assistance per se that I'm referring to. But what I'm saying is that a mediator assumes responsibility of facilitating the mediation process. He creates the environment, makes it possible for the parties to meet and talk. And he makes sure that every stage of the process is run within the context of the principles of...
So talking about alternative dispute resolution and the definitions you've given us and the roles you've defined for various participants in the process, I get the impression that it didn't even start in 2001 as stated in your books, because chiefs in various traditional areas, way before even Ghana attained independence, had resolved disputes between their people without necessarily going to court. In churches, at the mosque, at various institutions, disputes do arise, and these disputes are handled at that level without anyone necessarily reaching out to your office, for example, or to your other district offices. ADR has always been in existence. Why are we talking about it now? What's the difference?
Thank you very much. You are right. ADR is as old as Ghana. Even 1872, when the Supreme Court ordinance was enacted, if you look at it closely, you find settlements, mentioned within. And so our forefathers at various generations dealt with disputes with ADR. We have African way of solving dispute. So even this ADR we talk about, others call it African, alternative dispute resolution, African way of solving problems. Others say appropriate dispute resolution and all that. And so that is right. But what is going on now is a formalized, nature of ADR. Some of them were doing oral settlement. They did not reduce terms of settlement. They were not guided. There were no legislative backing and all that. This time, in Ghana, apart from 1961, when we had Act 38, which dealt with arbitration only, in 2010, Act 798 was passed. And it broadened the scope of alternative dispute resolution, providing for arbitration, mediation, customary arbitration, and other administrative interventions to enable our jurisprudence to properly take advantage of alternative dispute resolution. So what we are talking about now is that component of alternative dispute resolution customized to complement the court system to be faster and efficient.
Court-connected ADR. That's
DAPT court-connected ADR.
Then I'll return to an earlier question I asked when we were talking about the general ADR issues. Must persons involved in the court-connected ADR process be trained in a specific way? Do they have any certification? Tell us about the education.
Oh, yes, yes. ADR practice is now one of the enviable professions that people that are linked to the legal system and case management acquire to enable them live up to expectation. And so in the case of the judiciary, to enable us prosecute this ADR program, our training institute had to, build the capacity of personnel, mediators, in order to enable them host and implement the principles to support the system. So ADR practitioners require some level of training. The basic one will require a 40-hour training to enable a person to resolve basic, disputes. And there are various training up to becoming a chartered arbitrator, a chartered mediator, a chartered that, a chartered that, a chartered that. One does not need to necessarily be a lawyer to be an efficient arbitrator or mediator. And so we have a host of lawyers and non-lawyers with various backgrounds, and we even have some journalists involved.
But how does the process start in respect of court-connected ADR? So let me use a very popular example that we all know, the election petition which happened recently, when we know that the petitioner wanted the court to annul the votes, the elections of 2020, and therefore petitioned the Supreme Court to do so. What if the respondents, the EC, had probably gone to the court to say, look, I want ADR to handle this. And then the petitioner says, no, I'm not interested in any ADR. I insist that this must be handled by the Supreme Court. How do you handle this kind of situation? Because even therein lies a conflict.
That's right. Because you cited the elections petition as an example, let me provide information about that. It is not every case that is amenable to ADR.
That's right.
So Section 1 of Act 798 clearly spells out the nature of cases that are amenable to ADR. And one of them is the election petition case that you cite. They are cases of public interest. And once it is of public nature, it is only the traditional courts that are mandated to determine it. Okay. But ADR has indirectly influenced the demeanor of judges. So, irrespective of their power, they put up certain gestures and demeanor that, make the court very friendly and accommodating, so that people who are assessing justice before the judges will feel at home and present their case in the manner that they are committed to. And so sometimes it is not regular of a judge to be saying, please, please. Judges order people around in their courts. But even at the apex court, you heard the Chief Justice, when addressing lawyers and clients, please, please, please. All these things are the effects of, ADR that, makes judges so friendly and accommodating, so that people can function at their best in the courtrooms.
Right.
Yes. So cases such as criminal cases of felony are also not amenable to ADR. Cases per our ADR Act, environmental cases are not amenable. Many people have raised qualms with that, which I also agree, and maybe one day it will be looked at. We also have child abuse cases, domestic violence that entail sexual and psychological abuse. these cases are not amenable to ADR. Again, several cases in which fraud is pleaded. Okay, that, for instance, there is an allegation that a whale that is in issue was forged. You have made an allegation of a criminal conduct of against somebody, and for that matter, that particular case cannot go for ADR. The court will have to go into it because it had the same nature as proper criminal matter. And so we have other cases such as fraud, crime, and all that. But even in the case of criminal cases, we have minor criminal cases such as act ending, disturbing the peace of the public, and assault cases that are not aggravated in nature and all that. All these cases are amenable to ADR. Apart from that, all civil disputes, commercial cases, land cases, matrimonial cases, and all that are all cases that are amenable to ADR. Rent cases and all that.
Well, I totally get the education now, but still my question holds. Well, so whether it's on marital cases, I mean, or land disputes and so on, still the question is valid that I want to go to court.
Yes.
The other person says, no, let's go for ADR.
I think I have not addressed that one. Yes, so I have to address it. We have types of ADR processes.
Right.
But ADR is generally voluntary. Okay, so what most of the ADR processes we handle within the judiciary are voluntary. So just as you cited, if party A proposes to go for ADR and the other says no, I insist that the court proceeds with it, then it means that the case cannot go to ADR.
All right.
It is only when the parties agree that why not, let's go, then of course the process is legitimized.
But who initiates the conversation about engaging the ADR process in the first place? Because the people start as litigants. At what point do they become ADR pursuers and not litigants?
Before I come to that, let me conclude the first question by adding that we have voluntary processes and we have mandatory processes. So for instance, at the Commercial Court of Ghana, we have a mandatory pre-trial where when you file a case, the case, as soon as it is ripe for hearing, we say when pleadings close. When pleadings close, then the case will be ripe for pre-trial.
Yes.
The pre-trial session at the Commercial Court is ADR. So over there, one of the judges serves as a mediator for 30 days, giving the parties the opportunity to attempt settlements with ADR. It is when this opportunity given them to try ADR fails that they go into mainstream litigation. So the pre-trial system, being ADR at the Commercial Court, is mandatory. But the court-connected ADR, where parties, decide to go on their own, is voluntary. And so if one suggests and the other says, no, I'm not comfortable with ADR, so let's remain in the court, it means that the judge cannot, refer the case. You cannot impose the process on any of the parties.
Oh, okay.
So this is how it starts. We have about 3 weeks in which ADR is initiated. The first and foremost one is where the parties, if they are in a business transaction and there is a contract between them, and at the inception of the negotiation of the contract, the party says that we are human and the dynamics are unknown. Therefore, let us safeguard this business by making provision in our agreement for dispute resolution, so that in the event that in the course of time, through no fault of any one of us, there arises a dispute, we can adopt those measures in dealing with the matter. So one of the means by which ADR is initiated is by agreement. In an agreement, so if this is our agreement to supply goods to them, and in that agreement we make a provision further for an agreement that in the event that any one of us defaults, let us not go to court immediately. Let us use either mediation or negotiation or arbitration. Then you spell out the scope and the forum where you want it and the relevant laws and all that. So if you do that, and at a point in time a dispute arises, then of course you are both bound already to it. So one cannot go to court to say that I don't want ADR. Even when one of them ignores that provision and goes to court, and the court gets to know that there is an agreement between them in respect of that transaction that says that in the event of a dispute, they will use other means other than the court will put the hearing on hold and ask them to go and deal with the matter. That is one recommended mode of initiating alternative dispute resolution in a dispute, and it is the safest way to go. The second one is where a judge, before whom there is a dispute, thinks that an alternative means of resolving it is in the interest of justice. Then he recommends to the parties that I think this case you have to go for ADR.
Typical example, I'm a journalist. Recently, the GJA had been taken to court by another journalist because she thought that the executives had overstayed. And when the matter went to court, immediately the court indicated that this was a matter that could be handled through ADR, and therefore directed everyone involved and everyone who had been mentioned in the suit to
appear before, to attempt settlement out of court.
Yeah, that's true, and it was recommended by the court, and not that any of the parties involved, or that there was a prior contract within which such and such was stated.
That is the example I'm citing, and that is the second one.
Right.
The judge is the manager of his cases, and now by our laws, the judge has ADR as a tool to manage his cases. Well, so that judge was using ADR. So he says, I give you 1 week, 2 weeks to attempt settlement and report to me. That is one means by which ADR is initiated. So the parties can decide that, okay, we want the National ADR Coordinator's Office to handle the matter. They can come here. They can mention any other person they know that they prefer and trust can help them to deal with the matter.
Right.
So that is ADR. Then the third one is where one of the parties gets to know of the discussion, he follows and says, oh, I have a case in court. Next week when I go to court, I will tell the judge. The law says that that party can, upon the mentioning of the case, raise his hand that, my lord, your ladyship, your honor, your worship, please, if this case is amenable to ADR, kindly refer it to it for us. The judge will find out from the other party if he has no objection. If the other party agrees, the judge will refer it and give them time within which to report to the court as to whether they are able to settle or not. So this is how. But in your case, where the judge recommended, one of the parties could have objected that, no, my lord, we disagree. If they insist that they don't want ADR, the court would have obliged and continued. So that is it. Yes, that is how it functions. And so, so far, I think this is the answer to that loaded question.
But so, from 2001, and then I realized that the lot was done in between 2006 and so on and so forth. But how has the message to switch some cases to ADR sunk with Ghanaians?
I cannot measure how far it is sunk, but I can tell you how much we have done.
Tell me.
Good. Immediately the ADR program became a core component of our adjudication system. The Chief Justice then issued a policy directive requiring of this office to run ADR week every legal year. When we say every legal year term, every legal year term is like an academic semester or term.
Yes.
Okay, we have 3 within a year. And so every term in the legal year, the Chief Justice requires that the National ADR Office runs a nationwide public sensitization program called ADR Week. And in fact, the next one for this term falls on 8th of this month. That is Monday.
Yes.
And it is being launched in Eastern Region, Koforidua. In fact, since 2005, this public education has been consistently held. And we must be grateful to GBC. Almost every ADR week, GBC gives us the opportunity to tell people of ADR. And many of other media houses have also supported us. So as far as we are concerned, we have consistently since 2005 run programs and activities in the bid to reach out to Ghanaians with the knowledge of ADR, its importance, and how to assess it in the court. And we think that by that, a greater number of the people...
Your office as the ADR coordinator, do you also engage in training? Do you have a department that is open to people who want to get involved in this process for some training?
We have so far trained over 600 mediators nationwide, and we continue to do annually based upon budgetary,
of course,
budgetary capability. And so the Judicial Service itself is committed to the ADR program, and so the JTI, in collaboration with this department, run sensitization programs, training, and all that. Other institutions also come to request for training, and they are given by the Judicial Training Institute and all that. So yes, we have training program for mediators and judges and staff.
We have just a little under 10 minutes more to go. It's amazing how time has flown by.
The time has disappointed us.
But within the 10 minutes, let's do this.
Okay.
So you have the ADR week coming up. You say it's in Koforidua.
Yes.
What exactly are you doing there? Can you
Generally, the ADR week entails 2 major